Hi, I'm Hope Fry. I'm an immigration lawyer with 40 years of experience and executive director of Project Lifeline. This is the second of a four-part series talking about the Flores settlement and the proposed government regulations that would eviscerate it. On September 7, 2018, the Departments of Homeland Security and Health and Human Services proposed sweeping regulations that would substantially change how children and families are detained. The regulations would replace and sunset the Flores settlement, an agreement that protects the interests of children in immigration detention. This is the second of four parts talking about the regulations, and let's go back to the beginning and bring you up to date on the history of the Flores case. This discussion will create a context for understanding what the proposed regulations mean. In 1985, then 15-year-old Jenny Flores was held by Legacy INS in a broken-down, dilapidated hotel in East Los Angeles, along with adults of both sexes, with nothing to do and no supervision, a recipe for disaster. Jenny's aunt wanted to sponsor her release, but INS only allowed parents to serve as sponsors. Carlos Holguin, a brilliant human rights lawyer in the Center for Human Rights and Constitutional Law, brought a lawsuit on behalf of Jenny and all other detained children. In 1997, the government settled the case after fighting it vigorously for 12 years. The Flores settlement, called simply Flores, set the nationwide terms and conditions of the detention, release, and treatment of immigrant and refugee children. The settlement provides that the government would issue regulations within 120 days. It requires that the regulations be consistent with Flores. Although they could have issued regulations any time, the government didn't. So Flores has been the law for 21 years. Jenny Flores is 48 years old. The Center for Human Rights and Constitutional Law, the Flores lawyers, have gone to court a number of times to enforce compliance. Non-compliance was the overall finding. Fast forward to 2015 when Judge Dolly G. of the United States District Court for the Central District of California found that the government breached the Flores settlement. Among its many prior ensuing attempts to minimize capability, the federal government took her decision to the Ninth Circuit Court of Appeals and argued that Flores applied to only accompanied children and not, importantly, children who were detained with families. This is important to the proposed regs. The Ninth Circuit found that this applied to all children, whether they arrived in family units or unaccompanied. The judge found that the government had continued its practice of detaining children in, quote, deplorable and unsanitary conditions, unquote, failed to advise them of their rights under the agreement and interfered with the right to counsel, failed to make and record ongoing efforts aimed at the release of children, commingled children with unrelated adults for extended periods, and kept children locked in unlicensed facilities for weeks or months. The judge found that the children had inadequate access to food and drinking water, inadequate hygiene, bathroom soap, towels, toothbrushes, cold temperatures, and inadequate sleeping conditions, including 24-hour continuous light exposure. The judge gave the government a year to remedy all the violations she found. This summer, as the parties were due to return to court to assess compliance, the government filed what Judge G characterized as a cynical motion to modify Flores. One of the key modifications was the right to detain families in unlicensed facilities. The judge rejected the government's proposal, refusing to grant any part of their application. The compliance hearing was held on July 26th. Judge G found that the conditions of detention for children remained untenable, and she ordered the unusual step of the appointment of a special master to conduct independent oversights of all facilities where children are held.